Hi, and welcome to the show tonight. This is a prof show. Tonight's show is called Delphi, the Appeal, Part 3. Court denies Allen the right to present a defense. And we will be zooming in very closely to the ongoing appeal for Richard Allen and taking a close look at all of the relevant documents pertaining to Part 3 of the appellate argument, which is the judge, or the court, in this case, Judge Gull, in Delphi. Sorry about that. Denying Richard Allen the right to a fair trial. We're going to be looking at everything extremely closely with the documents, some analysis and commentary. Tonight is Monday, May 11th, for those of you on the live stream, and I appreciate you being here. Please enjoy the chat. Have an absolute fabulous time on the chat, and I'll be back with you in a couple minutes as we let people file in, and we will get the show underway without any delay. So God bless you. I hope you had a great weekend. All the mothers had a happy Mother's Day. And let's get ready to really discuss this essential aspect of the appeal, perhaps the most appalling aspect of the appeal, which is the clear bias and strong-arming by the judge in the trial of Richard Allen. So we'll see you momentarily. God bless.
Prof is a fucking terrorist, a fucking pedophile, sympathizing fucking terrorist. Fuck you. Fuck you. Fuck you.
Not productive, it's kind of gross and icky, and I feel like it tells us more about them than the people they're trying to degrade. They're always trying to degrade someone.
Prof is a fucking terrorist.
This stuff's coming to a close.
Prof is a fucking terrorist. Obsessed, junkie, stalker.
It was our job to help law enforcement.
It's not productive, it's kind of gross and icky.
Prof is a fucking terrorist. Fuck you.
It was our job to help law enforcement.
Prof is a fucking terrorist.
It's not productive, it's kind of gross and icky, and I feel like it tells us more about them than the people they're trying to degrade. They're always trying to degrade someone.
This stuff's coming to a close. There are more than one person involved with this case. It's not just Richard Allen.
It's not productive.
Prof is a fucking terrorist. A fucking pedophile, sympathizing fucking terrorist.
Bruh.
Prof is a fucking terrorist.
Bruh.
All right, and thank you. Hopefully the sound's okay. I didn't do a sound check. Just let me know if you cannot hear me well enough. I have just been extremely busy as usual, and you know how it is. All of us are usually extremely busy. It's the world we live in. But I'm glad to see everyone. And for those of you who are new here, um, there's a lot going on. There's a lot going on, and there is an extreme amount of skepticism around this case. And this case is extremely famous. For those of you who are new, you may know that this case went viral due to media. Okay. And by media, I don't mean the media, I mean the photograph of Abby on the bridge, one of the victims in this Delphi murders. And it's just so bizarre how things have turned out, because that initial impetus of the mysterious, haunting photo of a girl walking to her death on an old, dilapidated, spooky structure was really a hook. It was a hook that basically sunk into everyone who witnessed or first saw that photo and learned the fact that you had this mysterious photo of a girl on a bridge walking to her death. And for the first years, you had this photo and a short video clip of this anonymous monster who became infamously known as Bridge Guy, an indiscernible figure bundled up in several layers of clothing, walking on that same bridge. And as the years went on, more people were spellbound by this intriguing viral media. These were the hooks or the bait that caught everyone into this sphere of mystery, intrigue, curiosity, concern, and ultimately confusion. Because as time ticked on, more questions arose than answers. Whether it be the extreme amount of disinformation and misinformation spread on by bad actors on social media who were specifically put here to do that, or the really bizarre, intriguing, mysterious, what we've come to call riddling and theatrical performances of Douglas Carter, the superintendent and head spokesperson for law enforcement on this case. And as time went on, all of the very valid questions, as people looked at this with somewhat of a sense of skepticism and started to question all of this, whether it be questioning the media and looking at these photographs and videos and saying, you know what, something doesn't sit right with me about this photograph or that photograph, or this video or this press conference or this story that the families are telling. Um, the more time went on, the more questions arose, the more skepticism, and the more disbelief from the general public of what we were being told by law enforcement and some of the family members. And subsequently, this entire case turned into an absolute disaster, a circus, complete with doxing, harassment, terrorizing, threats, lawfare, deaths, ultimately leading to the railroading of a man that many believe are innocent, Richard Matthew Allen, an individual who was dropped on to this community like an atom bomb out of nowhere in October of all months. And I say that because as people became familiar with this case, they became familiar with the occult overtones in this case. And before much was known about the crime scene definitively, people had already figured out that this case was surrounded by a cloud of occult symbolism and vibes, whether it be in the all of the individuals tied to this case, looking into the social media of all those individuals, all the things that people interested in this case online have done and were doing. It all led us to this general sense of unease and a very, very sinister, spooky feeling arising from the appearance of some sort of death cult that was emanating out from the central core of this case that was perceptible on social media. And so before Richard Allen was dropped onto us, we had already established somewhat of a framework for what this case had to be about. Because what we saw was absolutely strange. We saw a community who seemed to be up to their necks in gore, death, methamphetamine, sexual deviancy, occult symbolism, occult practices, witchy poo shit, as I've described it many times. And so up until the point that Richard Allen was arrested, many of us were just trudging through the murk and mire of an abyss of dark feeling information around this case, and the feeling that this had to be something extremely sinister, extremely dark. I often termed it something like the Blair Witch vibe, okay? Very witchy, Wiccan, culty, sick. And as we did so, we were convinced that people from the community knew what happened to these victims. Absolutely convinced that the community was hiding something. And we started to tie in all of these, I would say, powerful individuals and their connections into the Masonic lodges, the sex clubs operating in and around the state, and going on with tentacles spreading on out through the country. as I mentioned, rumors of gore porn, or what was referred to at the time as a snuff film. Uh, there has been so much to this case, and honestly, since the arrest of Richard Allen, so much has been forgotten. Many questions have been forgotten, and remember, asking the right questions is always essential. And in some ways, because Richard Allen has been so predominant in this narrative, we've almost forgotten all of the other most important questions. But I say that to say Richard Allen was dropped on us in an occult time zone, I would say. And immediately questions arose because we all looked at the probable cause affidavit as soon as it was available, and we all dug into this character, Richard Allen. And none of it made sense because this probable cause affidavit was so extremely bungled and confusing and seemed to display a lacking of logic. And I remember the initial impression being we didn't know if they were talking about one individual, two individuals, three individuals, four individuals. We had no idea. All we knew is that that probable cause affidavit was absolutely garbage. And therefore, there were questions such as, well, was he involved? Surely law enforcement would not arrest someone who was not involved. Surely there must be others involved because this probable cause affidavit makes it seem like there were two or three individuals being described. And that started the ball rolling. And as things progressed and information surfaced, we all gained a very clear picture of what we were looking at. And amazingly, something that people seem to forget, the crime scene itself, as that information became more apparent because of the leaking of the crime scene photos by the very state actors, oddly enough, these very state actors who had been out here controlling the narrative for years, for some odd reason, chose to release the crime scene images. And I know not only what those images are, but I know who released them and who was behind it. And the truth has not been told about that. And I've been waiting for that individual to grow the backbone to step forward and tell the whole story and admit his part. But of course, he has no backbone because, like many who have deeply inserted themselves into this case to do the state's bidding, they have no backbone. They exercise no discernment, no visible logic. They only double down on the illogical, irrational, and emotional sentiment of he's the monster. Best if he's off the earth. But what they didn't realize is that that would only confirm our suspicions that had been built up over a period of 5 years, that this was an absolutely evil, sinister, disgusting, occult-ish action taken by the people who predated upon these girls. It's also why I've suggested many of you take it upon yourselves to see those crime scene photos, get to know them, see with your own two eyes what was done, how those girls were left in the woods, and then connect that with all of the first 5 years of research and investigation into this case, looking into the community and seeing all these characters surrounding the case and their occult overtones. And the questions remain. Because as the defense eventually released some of the law enforcement product, which the defense framed as the Franks Memorandum, but which came directly from the FBI and Unified Command in the early days, it was absolutely clear that there was a, to put it in the words of the first prosecutor, Robert Ives, there was definitely a non-secular component to this crime, which is a nice way of saying satanic, occultic, witchy poo, Satanist, disgusting, sigil-based tone of the crime scene, which perfectly matches up with all that we ever knew, which is why we had always demanded the community come clean. But of course, no. Community won't come clean. Family members won't come clean. Law enforcement won't come clean. They gaslight more than ever. They deny what they first worked. They deny, and you're going to see some of that tonight. But I mentioned the involvement of the higher ups because as we looked into these connections of family members, law enforcement, politicians, and others, consider the occult nature of this crime and think about the people in positions of power who all seem to have these ties to the secret societies. It became odd because we thought, what are they hiding? What is this community hiding? And what are these powerful individuals in charge hiding who just so happen to be related to each other and members of these secret societies? And I think as time passes, it becomes more and more clear what they are hiding. Because if you take it back to square one, which is how those girls were found, that crime scene, you look at that crime scene, and then you consider all of the theatrics of Doug Carter, all of the contradictions from law enforcement with the change of direction and all other things, all of the changing theories, all of the changing personnel, all of the resignations, all of the deaths, all of the harassment, all of the death threats, all of the denial of past words and the scrubbing of the internet of older media that said particularly important things, including non-secular signatures at the crime scene. All of that shit has been totally scrubbed from the internet. 85-90% of the individuals who had covered this case over the years had literally been threatened off the case because of the doxing, the harassment, the death threats, the threats to their family members, the shit showing up at their homes. It leads you to speculate. You've got all of these people in positions of power, members of secret societies, deeply involved in enforcing the trafficking in the area. And by that, I mean the meth trafficking, the heroin trafficking, the weed trafficking, and the sex trafficking. And all of these things start to come together to form a picture. And this picture makes sense because you look at this individual who was dropped like a bomb onto this community, Richard Allen, and you think, how does he have anything to do with any of this? No connections to meth. No connections to law enforcement. No connections to secret societies. No connections to sex trafficking. No connections to the occult or witchy poo shit. He doesn't make sense. He's not a tentacle. For years, people said, what did Doug Carter mean by the tentacles? Very complicated. Sketch is not a photograph. A killer could be in this room. Richard Allen doesn't make sense in that context. Not on Snapchat, not on Kick, not on Yellow or Yubo. He didn't make sense. Where are the tentacles? Well, it turns out the tentacles belong to the octopus, and the octopus is the head of this game. And it starts to make sense why all of this media would be faked. Why would there be fake photography with no provenance that's not found on the victim's phone? Why would there be a video that's dropped by a bunch of fucking YouTubers years later? A video is dropped onto the phone that appears to be AI upscaled. It's absolutely not the original video off the girl's phone. And if it is the original video off the girl's phone, you have to ask, how in the world was it AI upscaled in 2017 and planted on the phone before it was planted under one of the victims? Absolutely nothing makes sense. And where is the Disney and NASA product regarding this footage? Why do we have individuals in this community who are tied to the elite? We have former deputy attorney generals and their children, hackers, several computer programmers, several high-ranking lawyers. People coordinating this investigation coming straight out of the meth unit for the state. Nothing makes sense. And so when we consider all of that and we think about this judge, which is the topic of the show tonight, and the judge's blatant prejudicial bias, not only the appearance of bias, but the obvious and blatant bias. Absolute control of the outcome of this case through her actions alone. And you think, wow, what was this judge trying to do? And so tonight, that's what we're going to look at. And I want you to consider, because every single thing you're going to hear tonight is absolute fact. There's no theorying, no theorizing, no speculation, no rumor, no misinformation, disinformation. Absolute fact. And you know, the odd thing here is that there's no one else out here doing this. Where is everybody else? We have an entire world of individuals. Shit, we have at least 100 individuals out here who claim to be creators. Where are they? All we end up with is a couple people spreading misinformation and disinformation, and a lone warrior out here giving you the facts. It's interesting. It's really curious. But if I don't do it, who will? So, as I mentioned, we're going to be looking at part 3 of the appeal, which was the court denying Richard Allen the right to present a defense tonight. And then in subsequent episodes, we're going to look at other aspects of the appeal. Okay? And I'm doing this because I want you who happen to see this video to have an absolutely rock solid understanding of this appeal. Because we're currently waiting on the next step in this appeal, which is either going to be oral arguments in a decision, or it's just going to be a decision. We don't know. But in any case, this has come down to this. And so we'll take a very, very close zoomed in look on it so that all of you go or come away from this experts in this appeal. And tonight, experts in the court denying Richard Allen the right to present a defense. So please get comfortable and we will dive right in. Apologize for that. Wrong one. There you go. Now, if you take a close look at the top of the page, you will see that this is from the initial appellant's brief. In other words, this is the appeal, quote unquote, as most lay people would phrase it. This is the appeal. And you can see here in Roman numeral number 3 here, page 86, meaning this is the third component of the appeal. So this appeal stands on 3 legs, right? And the 3 legs are the illegal search based on a deceptive probable cause affidavit for a search warrant. Number 2, the false confessions. And number 3, the denial of Mr. Allen's right to present a complete defense, to explain the scene and impeach the investigation. So what I've done for you guys is I have highlighted the most essential concepts in each paragraph, okay, as we go through this. And as I mentioned, you can see here we're starting on page 86 of the appellant's brief. This is document number 1 in the appeal. It says the 14th Amendment guarantees a defendant the right to a fair trial. And as I mentioned, because it's highlighted, that's a particularly important point. 14th Amendment constitutional violation here. The amendment's due process clause, due process, places significant substantive limits on state power, prohibiting its arbitrary exertion and guaranteeing criminal defendants a fair opportunity to defend against the state's accusations. For an opportunity to be fair, a defendant must be permitted to confront and cross-examine witnesses and to call witnesses in his or her own behalf. Hey, thank you, Swade Smith. Swade Smith says, free Rick Allen. Thank you, Swade. Free Rick Allen. These overarching principles operate in tandem with the Sixth Amendment, which similarly guarantees criminal defendants a meaningful opportunity to present a complete defense. Fair trial, complete defense. 14th and 6th Amendments, constitutional violations. Although trial courts have broad discretion in conducting trials, this discretion has constitutional limits. And again, because I have highlighted it, it means something that it's important to me. That is, courts may not infringe upon a weighty interest of the accused through decisions that are arbitrary or disproportionate to the purposes they are designed to serve. As explained more fully below, the trial court made several reversible errors under the rules of evidence and Indiana's trial rules. In many instances, these decisions violated the Constitution as well. So what's being said there, and that's why I highlighted it. Hey, thank you, MJ Lewis, 1964 for the $9.99 super chat. Thank you, MJ Lewis. The trial court made several reversible errors, is the claim, under the rules of evidence and Indiana trial rules. So that's Indiana rules and 14th and 6th Amendment rules. Okay. While this court assesses claims relating to admitting or excluding evidence for abuse of discretion, to the extent those claims implicate constitutional issues, this court reviews them de novo. Errors in the admission of evidence will be disregarded as harmless, and this is important because the harmless is the claim that the state is making in rebuttal, so we'll hear that momentarily. So it says the errors are harmless if its probable impact on the jury, in light of all the evidence in the case, is sufficiently minor so as to not affect the substantial rights of the parties. So you see how that's a little obscure in language? You know what I'm saying? That's a little obscure, isn't it? It's not really very clear legal language. It's open to some interpretation here. It says it's disregarded. Okay, so these errors are disregarded if in totality each little error can be, okay, so each little error can be disregarded if in totality it is considered sufficiently minor so it would not affect the aforementioned rights, which is to present a complete defense, the right to a fair trial, and the rules of evidence. But when the error is constitutional, the standard is higher. When the error is constitutional, the standard is higher. So in other words, for the 14th and 6th Amendments, for the right to a fair trial, the right to present a complete defense, the standard is higher. Generally, before a federal constitutional error can be held harmless, the court, and here's the important part, must be able to declare a belief that it was harmless beyond a reasonable doubt. So that's a high bar, right? That's a high bar there. So each determination of harmlessness of each error must be determined beyond a reasonable doubt to be harmless. So that's an important concept to remember, in my opinion. So now we're going to go down the bullet points of what the harmless errors are. Okay, so now we're going to look particularly at each little bullet point. So what are the errors that are being claimed? Because look, we know for sure, we know for sure that this appeal here only captured maybe 30% of everything that was done in this trial and investigation. Look, 30% at a maximum. This is so minimal what the appellate attorneys chose to bring because there was so much wrong. Have all you guys out there realized that? You know, this appeal, in other words, what I'm saying, this appeal could have been 3 times stronger or 3 times fatter or chunkier or more full of information. So this is only a third. But here are your points, okay? The Betsy Blair sketch being ruled inadmissible. Okay, so that's what you need to know. At trial, Judge Gold prohibited Allen from using Betsy Blair's sketch of Bridge Guy. This decision violated Indiana's rules of evidence and denied Allen his federal constitutional right to present a defense of mistaken identity. Mistaken identity. So think about this. When you discuss with people Betsy Blair's sketch being excluded, the concept is that it was going to be used to prove that the identity of Allen was mistaken because Betsy Blair's sketch could not have been Allen. And that is simultaneously an Indiana rules of evidence violation and a federal constitutional violation to present a defense. Sixth Amendment. Evidence is relevant when it has any tendency to make the existence of any fact that the state is claiming that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. In other words, depends on how would this matter to the jury, this sketch here that we're about to see. A court may exclude relevant evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. So let's think about that. How is this confusing or misleading to the jury to show this sketch? Blair's sketch proves she did not see Allen on the bridge. Okay, Blair's sketch, which she rated a 10 out of 10, proves she did not see Allen on the bridge. Blair did not identify Allen in court as Bridge Guy. But according to the prosecutor, Slick Dick McClellan, Blair must have seen Allen on the bridge because Allen told us he went out onto the high bridge on the first platform, which is exactly where Blair saw Bridge Guy. And I've said in a previous stream, oh, so you're telling me no one else can ever sit in this chair? No one else can sit in this chair. So I'm sitting in a chair now, but if someone else sits in this chair an hour, is it necessary that that person is me? Well, what if it's in 5 minutes? What if I'm sitting in this chair and I get up and 5 minutes later someone else is sitting in this chair? Does that mean that I'm still sitting in the chair? Blair's sketch shows Allen looked nothing like the person Blair saw. Just 3 days after the murders, Blair met with a sketch artist and described the man she saw on the bridge as white. Okay, check. About 20, nope. X. Of medium build, nope. X. And having curly brown hair, nope. X. Okay, so I guess Richard Allen's white. So he's white and on the bridge. So, okay, let me revise my analogy to sitting in my own chair. So let's say if I'm sitting in my chair and I'm white, and then 5 minutes later, another white man is sitting in my chair. Does it demand that I am still sitting in the chair or it's me in the chair because the other man sitting in my chair is white, which is the only thing that matches Blair's description to Allen? An artist created the following sketch based on her description. Right here. This looks nothing like Alan. At the time of the murders, Alan was short, kind of tubby, 44 years old, with closely cropped hair. Blair's sketch also shows that she and Carbaugh saw different people. The state's timeline for the murders is dependent upon Blair and Carbaugh seeing the same person. The prosecutor told the jury that every eyewitness is adamant that the person they saw was Bridge Guy. There's no doubt in their minds. But Blair's sketch disproves this claim. Carbaugh, like Blair, made a sketch. When Blair saw it, she described it as wrong and not who she saw. Blair's sketch impeaches the investigation and shows law enforcement bias against Allen. For 2 years, law enforcement circulated Carbaugh's sketch without it yielding a single arrest. So in 2019, April, ISP released Betsy Blair's sketch and declared it represented the face of Bridge Guy. And they also announced that Blair and Carbaugh did not see the same person. So remember that up here I've highlighted Blair saw it and described it as wrong and not who she saw when she saw Sarah Carbaugh's sketch. ISP released her sketch and declared that Blair and Carbaugh did not see the same person. But remember, up at the top here, it says the state's timeline for the murders is dependent upon Carbaugh and Blair seeing the same person. So here we have a huge disconnect. The sketch is extremely important because it proves that Blair did not see Richard Allen. She did not identify Richard Allen as Bridge Guy. She also says Carbaugh's sketch is wrong and it's not the person she saw, which is backed up by law enforcement who said in 2019 Blair and Carbaugh did not see the same person. But of course, and here's a red flag, after Allen's arrest, the story changed. The story changed. And the jury was told falsely, the jury was lied to by the state and was told that Carbaugh and Blair saw the very exact same person. Blair's sketch was reliable and probative of Bridge Guy's identity. Blair contacted law enforcement the day the girls went missing, and it was very clear to her she saw Bridge Guy. 2 days later, she developed her sketch with an artist and a book of facial features. She rated her sketch 10 out of 10 for accuracy. In 2019, she met with law enforcement again repeatedly, and she reaffirmed her confidence in her sketch. 9 out of 10 for accuracy. She insisted that she could identify Bridge Guy if she saw him. Now listen to that one, because I think a lot of us miss this. Betsy Blair insisted that she could identify Bridge Guy if she saw him. So why didn't she identify him in court? Blair's sketch is not hearsay. Indiana bars the use of out-of-court statements for truth of the matter asserted unless the statement falls within an exception. Here, Blair's sketch was not a statement. Although Indiana has not reached the issue, other courts hold that a sketch is the functional equivalent of a photograph. No statement is involved. The sketch is not hearsay. A statement is not hearsay if the declarant testifies she did, and is subject to cross-examination about a prior statement, and the statement she did is an identification of a person shortly after perceiving. And it was. So that checks all the boxes, meaning the sketch is not hearsay. The rule applies regardless of whether the identifying witness makes a positive in-court identification or not. Here, Blair identified Bridge Guy to law enforcement immediately and developed her sketch 3 days later. Blair's sketch is also admissible as an adoptive admission. A statement is not hearsay when it is offered against an opposing party and is one the party manifested that it adopted or believed to be true. That occurred here because in April 2019, the Indiana State Police released Blair's sketch to the public and declared, "This is the face of Bridge Guy," meaning they adopted it or believed it to be true. This is the face of Bridge Guy. Okay? Blair's sketch is admissible under Indiana's common law too. Decades before Indiana adopted the rules of evidence, sketches were admissible if the eyewitness took the stand at trial. Betsy Blair took the stand at trial. The sketch should have been admissible for, that's 4 to 5 reasons there. Now, the backup here, or the caveat is, even if the court determines that the sketch was inadmissible and hearsay, Allen was still entitled to use it. State law does not have the last word on hearsay, and the rule must yield to the constitutional right to present a defense. So listen to that one too for those in the back, the ones coming in the chat with bullshit. Even if the sketch is declared hearsay, Allen was still entitled to use it because state law does not have the last word on hearsay, and the rule of admissibility must yield to the constitutional right to present a defense. When identity is crucial to the case, a defendant is entitled to defend on a claim of mistaken identity, and that was exactly what that was supposed to be used for. This right cannot be abridged through the application of arbitrary, disproportionate rules or the mechanistic application of otherwise rational rules. Excluding the sketch violated the Constitution. Here, the state concedes that Bridge Guy's identity was crucial to the case. If we can determine who Bridge Guy is, we can determine who killed Abby and Libby. Blair's sketch, in this case, was critical to Allen's defense of mistaken identity, and the judge's decision to exclude if it was arbitrary, exclude it was arbitrary and disproportionate to any legitimate government interest. The error was harmful under both constitutional harmless error standard and Indiana's evidentiary standard. There's no dispute the state's timeline depended upon Blair seeing Allen on the bridge and Blair and Carbaugh seeing the same person. Blair's sketch disproved both points. Excluding it affected Allen's substantial right to the jury's verdict. Okay. So now we're going to pivot here. We've just gone through all the middle section there on the sketch of Betsy Blair. So now let's take a little review on the state's response to this, okay? So this is going to be the state's response. It says the trial court made proper rulings, okay? The trial court's evidentiary rulings were correct and did not deprive Allen of his right to present a defense. Trial judges are better at making evidentiary calls than the appellate judges. Therefore, the trial courts are given wide deference. In other words, you got to give Judge Gull wide deference. In many cases, a court could admit or exclude evidence, and an appellate court won't meddle with that decision on an appeal. So in other words, this is McClellan begging the appellate court to give Judge Gull wide deference. Don't meddle in her decision. Evidentiary rulings are reviewed only for a manifest abuse of discretion. Oh, well, that's what we got here. This is the whole claim that's been making. Abuse of her power. And they say an erroneous evidentiary ruling is harmless if given all the evidence in the case. The error's probable impact does not undermine confidence in the outcome. Oh, it does undermine confidence. And unknowingly, federal constitutional errors must be harmless beyond a reasonable doubt, meaning that they did not contribute to the verdict. Okay. Whoops. You idiots should have just left that out. So this is the state admitting its own high bar for harmless. Okay. So to say this is harmless error is to claim not only is it harmless error, but you are alleging, state of Indiana, that this error, each error is harmless beyond a reasonable doubt in that each error did not contribute to the guilty verdict. The constitutional right to present a defense is not absolute. So here's another. This is the constant downplaying. This is the constant minimizing of the important issues here. It's not absolute, a constitutional right to present a defense. Defendants must comply with well-established rules of evidence to assure both fairness and reliability in the ascertainment of guilt and innocence. The right to present a defense trumps an evidentiary rule only when the rule is arbitrary or disproportionate to the purpose it is designed to serve. Well, that's the exact argument the appellate attorneys are making for Richard Allen. They're saying disproportionate, biased rulings. Okay. Now on to the investigatory sketch of Bridge Guy by Betsy Blair. Allen has waived this issue. False. The trial court granted the state's motion in limine to exclude the police sketch drawn from Blair's description of the man she saw on the bridge. So in other words, the state, the prosecutor here, Nicholas McClellan, submitted a motion in limine to exclude the sketch, right, from Blair. The trial court ruled on that motion in limine saying the sketch is excluded. Allen did not attempt to introduce Blair's sketch at trial because it was excluded. So he has waived the issue. No, well, that's going to be addressed in the response we'll get to shortly. Waiver notwithstanding. So here's a backup. Okay, because they know this waiver bullshit is bullshit. So now we're getting to the actual issue because all of this was fluff, this entire page. Blair's police sketch was inadmissible. Okay, so now he's going to admissibility. Allen sought to admit Blair's sketch as substantive evidence that Blair did not see Allen on the bridge. Exactly. mistaken identity. But the sketch was not relevant for this purpose because, as the trial court noted, Allen concedes Blair did not make an eyewitness identification of Allen as the man on the bridge. So you guys see the gaslighting and the circular arguments that are being made here to deceive the public? So let's just say what some facts are. Blair did not make an eyewitness identification of Allen as the man on the bridge. Right. Blair, remember what we read earlier. Blair said she definitely could. Let's go back to that, actually. Look at the absolute bottom of the page here in 89 in the appellant's brief. Betsy Blair insisted that she could identify Bridge Guy if she saw him. Blair did not make an eyewitness identification of Allen as the man on the bridge. Is that de facto admission that she did not see Allen? Because she claimed, she swore, she was adamant that she could identify Bridge Guy if she saw him. Did she not see Allen in court? Blair identified Bridge Guy as the man she saw on the platform of the bridge. She did not identify Allen as Bridge Guy. Uh-oh, I need an annoying sound effect for this. Oh my God.
Oh my God.
Bruh. Blair identified Bridge Guy as the man she saw on that platform on the bridge. She did not identify Allen as Bridge Guy. Hey, just a moment here. Allen's identification as Bridge Guy came from Allen identifying himself as the man Wilbur and Voorhees saw and identified as Bridge Guy. False, though. See, that's another place where it's not logical. It's not logical because that makes the assumption that Bree Wilbur and Rayleigh Voorhees saw Richard Allen. But that's a bad assumption because they also did not identify Allen as the guy that they saw. So Wilbur and Voorhees did not identify Allen as the person they saw. But the state's gaslight or the circular argument here is that Allen identified himself and placed himself on the platform at the right time to be the man Blair saw there, which is assuming that Allen was right in giving his times. It's assuming that Doolin was giving his times. Sorry, just a moment. I'm trying to take care of a technical difficulty I'm having here. I'm working on it. Okay, great. Further, any slight probative value was substantially outweighed by the danger of unfair prejudice and confusion. It was undisputed that composite sketches are used as an investigatory tool to generate leads and are not used to identify or exclude a suspect. Blair's sketch was an artist's interpretation of her description of Bridge Guy, and it was impossible to remove artist bias. Just like in this case, it's impossible to remove judicial bias. And the gaslighting continues. The danger of unfair prejudice was twofold. The jury could misuse the unreliable sketch as substantive evidence, and two, the jury could misuse the sketch to exclude Allen when Blair had not purported to identify Allen. So they're admitting that Blair is not identifying Allen. Allen's use of the sketch would have misled and confused the jury. No, that's opinion. It would have given the jury the reasonable the information that any reasonable person would want to know to try to make a determination about the validity or substance of that information. That's not misleading and confusing the jury. That's giving the jury the information they need to make the best decision. But instead, what you should really be saying here is that this would have misled and confused the jury about your bullshit narrative that you're trying to convince them of, prosecutor. The sketch was also inadmissible hearsay. No, it wasn't. Evidence Rule 801 D1C allows a prior statement of identification because those statements are believed to be reliable. Blair's sketch was not a prior identification of Allen, so it could not use it as substantive evidence that she did not identify him. So you see what I'm saying here? They're also admitting she did not identify Allen, but isn't it odd that they have to try to twist it into this version of saying it in this way, that her sketch was not a prior identification of Allen? Of course it wasn't. Whenever is, this is a pointless statement. When is a sketch ever a prior identification of Allen or any suspect? A sketch is not a prior identification. And then they keep the gaslight. The rule is a means of positive identification shortly after perceiving the person, which is when she produced the sketch. It would not apply to a prior identification of a different person. Are they admitting here it's a different person? Look here. It would not apply to a prior identification of a different person, which was the defense's exact angle to use it to prove that she identified a different person. Allen's new claim that the sketch was impeachment evidence is waived because he did not offer it for that reason or attempt to impeach Blair with it, because it was not allowed because you had already submitted the motion and eliminated, keep it out. Allen's new claim that the sketch, moreover, it would have been cumulative. On cross-examination, Blair testified that she had described a man she saw as young, boyish man in his 20s or 30s, of average height, well, maybe, with brown poofy hair and no visible facial hair, no. So you see, they're also admitting here Blair did not describe Allen. The jury could compare this description with Allen and the Bridge Guy. Allen makes no persuasive argument that the sketch would have been any more impeaching than Blair's description of the person. It would have. The sketch is entirely different than just a physical description. It's much more visual. Some people do not have the capacity to think in the same way or visualize in the same way. They need the sketch in their face. Any error was harmless due to the overwhelming evidence of guilt. That's why I highlighted that one. See that? Overwhelming evidence of guilt.
Oh my God.
Bruh.
Bruh.
Overwhelming evidence of guilt.
Legally blind.
Prof is a fucking terrorist.
State actors, they're going to tell you I'm a terrorist. Okay. Look, I guess I am terrorizing the state actor, the state. Okay. So now we're going to go to this reply to all of this because we're still centering on the sketch. Okay. We're down here at the bottom of the page. The trial court denied Allen his right to present a complete defense to explain the scene and impeach the investigation. The criminal defendant has federal and state constitutional rights to present a complete defense. Evidentiary rules that exclude critical defense evidence on grounds disconnected from the rule's purpose violate that right. The trial court's ruling on 7 categories of defense evidence violated that right and require reversal. And the state's contrary arguments are unpersuasive. Yeah, to say the least. Unpersuasive, I guess. It's a good way to say it. Okay. Now, on to the issue here. The trial court committed reversible error by excluding Blair's sketch of Bridge Guy. No eyewitness identified Allen as Bridge Guy at trial. And that's for all of you in the back. You know who. You guys coming in the chat trying to troll and getting stomped out like the cockroaches that you are. Yeah, you little hater bitches. You little hate watchers looking right now. You little chomo, child touching, CSAM watching, meth smoking, gun toting, high school dropout, and in some case junior high, bloodlusty, ignorant, rage-filled, single, ignorant, Jerry Holman butt crack licking jackasses. You guys, yeah, that's what I'm talking to you. No eyewitness identified Rick Allen as Bridge Guy. Because he wasn't. To prove Allen was Bridge Guy, the state rested its case on a compressed fucking bullshit timeline where every witness was twisted, bullied, coached, and compelled, i.e. needed, to have seen the same person. Blair did not see Allen, and her sketch proves it. The issue is preserved because the state argues waiver that Allen made no offer of proof at trial. That argument rests on abrogated case law since 2014, which means right now,
Bruh.
Evidence Rule 103B has provided that once a court rules definitively on the record, a party need not renew an objection or make an offer of proof to preserve error for appeal. That is what has occurred here. The court needed a hearing where the parties argued extensively whether Blair's sketch was admissible and issued a definitive ruling prohibiting the defense from using the composite sketches in the trial and the cause. Do you guys understand what I'm saying? You guys understand what I'm saying? Let's read that closely. I'm going to zoom in. This is for the idiots like the Chomo. Okay, the Chomo. Hey, Chomo. Chomo, I noticed you talked a lot of shit today. Chomo. Well, first of all, it's kind of scary and obsessed that you're scary and creepy that you're obsessed with me. And especially since I have a young man in the house, I'm really afraid of and creeped out by that. So how about you keep my name out your mouth? But hey, Chomo, I say you're pretty upset, but let's straighten you out on this, Chomo. Okay. Chomo, Since 2014, Chomo, Evidence Rule 103B, Chomo, has provided that once a court rules definitively on the record, Chomo, a party need not renew an objection to make or make an offer of proof to preserve the error for a reprieve, you fucking Chomo. The court held a hearing, Chomo, where the parties argued extensively whether or not Blair's sketch was admissible or inadmissible, Chomo. And she then issued a definitive written ruling, Chomo, prohibiting the fucking defense from using composite sketches in the trial. Okay, Chomo? So there was no waiver. So I hope that I've explained that to the Chomo well enough. But we know he's been hit on the head too many times, and he's touched too many children, so he doesn't understand what's actually being said here. He needs this case to be buried because of the drop box, most likely. Okay. Now, Chomo aside, moving on, the sketch was relevant because it was proof that Betsy Blair did not see Richard Allen, and it was not unfairly prejudicial. The state argues that the sketch was irrelevant because Blair never identified Allen as bridge guy. The state has the fucking logic backwards, Troll Farm. The sketch is relevant precisely because it proves Blair never saw Allen at all. Boo, 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 boo. She saw this man. Just 3 days after the murders, Betsy Blair described the man she saw on the bridge as white. Check. Approximately 20 years old. Nope. Medium build, nope. With brown curly hair, nope. At the time of the murders, Allen was 44 years old with a beer gut, closely cropped hair he had since 1989. It's not Richard Allen. All you have to do is look at it. Remember, she said it was a 10 out of 10. That's damn near a photograph. Damn near a photograph. A sketch can serve as evidence of innocence to prove someone else committed the crime. Okay, so listen. This is Indiana Courts of Appeal. So I think some of us have missed this. So all my amazing people in the chat, y'all check this one out. Indiana Court of Appeal, 1985. This is Indiana appellate precedent here. According to Indiana Court of Appeals, 1985, Kooky v. State, a sketch can serve as substantive evidence of innocence to prove someone else committed the crime. Blair's sketch does exactly that. The state claims the sketch was unfairly prejudicial because the jury might use it to exclude Allen as bridge guy. That's not unfair prejudice. That's the sketch's probative value, bruh.
Bruh.
Prejudice is not unfair simply because it undermines the prosecution's theory of the case. The state made Blair a cornerstone of its identification theory. Yeah, think about it. Without Blair, there's no state's theory here. Don't work. It doesn't work. Telling the jury in closing, like McClellan did, that every witness is adamant that the person they saw is bridge guy, with no doubt in their minds, and that Allen was on the bridge exactly where Blair saw bridge guy. Having built the case on Blair's observations, the state cannot simultaneously claim that what Blair observed and captured in a sketch she rated 10 out of 10 for accuracy and declared reliable as the face of bridge guy until Allen's arrest was too unreliable for the jury to see. The state also argues that the sketch was cumulative because Allen elicited Blair's verbal description on cross-examination. A syllogism is not a story. And you know, this is a great point that these appellate attorneys are making. They're absolutely fabulous. What is a syllogism? Well, that perfectly sums up the state's or the prosecution's theory of the case, right? That's the perfect summary of the prosecution's theory of the case, is this syllogistic rationale, which is Richard Allen was on the trails. The people saw Bridge Guy. Bridge Guy killed the girls, or something along those lines. Like, what? There's a missing link there, and it's right in the middle. You know what I'm saying? That it's sort of the way that syllogisms fall apart. If that middle, if that second point is illogical, then it's not a true logical chain there. So yeah, Richard Allen's on the trail. There's a missing part, and then Bridge Guy kills the girls. Okay, so then it doesn't work. Blair's description, broken into fragments by questions from lawyers, is no substitute for the sketch's persuasive force. And this is the point I've made about visual impact. Only by viewing the complete image, the full face that Blair drew 3 days after the murders, could the jury appreciate Allen's claims of innocence and appreciate the gravity of the difference in the sketch from Richard Allen's appearance. The persuasive power of the concrete and particular, as in a sketch or an image, is essential to the capacity of jurors to satisfy the obligations that the law places on them. Moreover, the sketch carried a probative force beyond the identification question. For 2 years, law enforcement circulated Carbaugh's fucking sketch without an arrest. In April 2019, ISP released Betsy Blair's sketch, declared it the face of Bridge Guy, and announced Blair and Carbaugh did not see the same person. After Allen's arrest, of course, the state reversed their story. This is about the third or fourth time the state has changed their stories in this murder because it's a cover-up of monumental proportions. The sketch placed before the jury alongside that reversal would have told the story of an investigation, quote unquote, that changed its theory when it came convenient and necessary to railroad a man. A story Blair's verbal testimony alone could not tell. Furthermore, the sketch was not hearsay, and even if it was admissible. A composite sketch is a visual depiction, not a statement, within the meaning of Rule 801A. It depicts rather than asserts. When courts across the country have encountered this question, they agree. The state does not dispute this and confines itself to arguing waiver, but as shown above, the issue was preserved. Even if treated as a statement, the sketch is admissible on two independent other grounds. First, Rule 801D1C excludes from hearsay, here you go, a prior identification of a person made after perceiving that person, where the declarant testifies and is subject to cross-examination. The rule applies to identification of a person. The drafters did not limit it to identification of the defendant. Bruh. The state offers no authority to the contrary. Secondly, the sketch is an adoptive admission under Rule 801D2B. The state, through the ISP, manifested adoption when it publicly released Blair's sketch in April 2019 and declared it the face of Bridge Guy, and announced that Blair and Carbaugh saw different men. The state cannot formally adopt the sketch as authoritative and announce it to the world before Allen's arrest and then completely bar its use at trial. Now, don't you guys agree with that? Do you think it's egregious? That from 2019 on, not only the website for Carroll County and Unified Command and the ISP, but even the FBI, they all had Betsy Blair's sketch up as the face of Bridge Guy. Right up until and after Allen's arrest, it was still up on those websites as the face of Bridge Guy. And you know how I know? Because I took screenshots to document it after Allen's arrest, a good, I don't know, 6 months. So even after Allen's arrest, that Betsy Blair sketch stayed up there asking for tips on the Delphi murders. All right, let's see. So let's see if I can I do a poll? God, I can't use my computer tonight or what? Just a moment. All right, I feel like I need a go get a drink out of the fridge and a piece of chocolate. So sorry, I'm been up since 4 this morning. So pretty tired already. Let's see if we can move forward with this. Here we go. All right, that's what it's going to be. We're up. That's what's next up on deck. So let me go get my drink, you guys, and chocolate. Okay, you know what's nuts? Every time you tell the truth about this case, the psychos or the maniacs come in the chat and wish death upon you. Like I said, this case is sadistic. It's witchy poo. It's full of a bunch of meth heads, chomos, perverts, and high school dropouts, and people who have relations with their sisters and daughters. You know, Carroll County's finest. So that's who's coming in here to, I guess, throw temper tantrums. Troll Farm throws temper tantrums, especially when they're out of the crack rocks and ice. So sorry, Troll Farm, ain't got no crack. I know you're all out of crack rocks and ice. So try to control the tempers, okay? Go find some dog in the backyard to get your rocks off with. Okay, now moving on. William Tobin, okay? The second essential point here. Oh, by the way, you guys like this? You know what this is? Coconut. Pretty good with it. William Tobin. Allen tendered William Tobin to explain the scientific community's robust criticism of AFTE's tool-mark matching methodology. The judge excluded him because he was not a quote-unquote firearms expert. He was untrained in firearms identification. He did not examine the evidence in this case. He did not conduct a firearms examination. According to the court, Tobin's testimony, quote unquote, does not go to an issue before the jury and lacks relevance. Whoo, terrible ruling. This decision violated our rules of evidence and violated Allen's constitutional right to present a defense. Expert testimony should be admitted if the expert is qualified by knowledge, skill, experience, training, or education. The testimony will help the trier of fact to understand the evidence or determine a fact in the issue. Indiana adopted this rule to liberalize the admission of expert opinion. Tobin was clearly qualified to explain the scientific community's robust criticism of the AFTE methodology. He's a nationally recognized expert in forensic metallurgy and material science who's testified as an expert in many cases involving the validity and reliability of firearms and tool marks. He has extensive experience in metallurgy, bullet and lead analysis, and tool mark principles, along with a background in statistics. He understands the President's Council of Advisors on Science and Technology, which has issued a detailed report criticizing the AFTE methodology. Tobin's testimony was essential for assessing Oberg's credibility and determining what to believe. Once an expert takes the stand, their credibility is fair game for impeachment. And a party is free to challenge the expert's methodology with opposing testimony from another expert. The jury is ultimately responsible for asserting witness credibility and determining what to believe. Here, Oberg testified that she matched tool marks on test firings from Allen's gun with tool marks on the unspent cartridge found at the murder scene. Oberg told the jury she found agreement between the tool marks by using AFTE methodology and gave an error rate of 2.2% for false positives and 2.87 for false negatives. So in other words, there's a 2% chance that it's ever wrong, but I've never been wrong. She discussed studies and articles that she reviewed to apply the methodology, and over relevancy objections, she described studies relating to guns that were not even 6-hour Model P239s. A lay juror might find this testimony impressive and coherent, but AFTE's methodology is anything but straightforward. Tobin's experience would help a jury understand the scientific community's criticism of AFTE's subjective methodology and force Oberg to engage with that critique. In other words, it would have educated, let's put it in real language. Tobin's testimony would have educated the jury on the tool mark analysis and ballistics and all of this shit with the bullet. As we all know, an educated jury is the last thing they wanted in this trial. That's why they got these dingbats that you've heard from out here on social media after trial. The last thing they wanted was an educated jury. So when it came to allowing this guy to take the stand and school the jury on some perspective, to give them a little education, a little wider perspective so that they can sit back and then determine what they think about the evidence. Nope, not allowed. Not allowed in. Done. Okay, done. We're not allowing him in. We're not allowing him to instill reasonable doubt into the jury's minds. Even if our rules tolerated Tobin's exclusion, the decision was patently unconstitutional. Now, this means this is a different argument here. A defendant is entitled to a meaningful opportunity to present a complete defense. This entitles him to impeach a witness who provides a crucial link in the proof. Remember, according to the state, this is the only evidence they have. Remember, there was no DNA of Richard Allen's at the scene. No eyewitness could identify him out there at that time. No clear video footage of him, right? No cellular geofence data, nothing. No messaging with the girls, no finding the girls on Facebook, nothing with Richard Allen except one piece of evidence. And it was a shoddy junk science, bullshit, ballistics, or bullet evidence. The crucial link in the proof of the defendant's guilt. Although trial courts possess broad discretion to limit impeachment, the discretion cannot be used to arbitrarily exclude competent, reliable evidence bearing on witness credibility when such evidence is central to the defendant's claims of innocence. Oberg's credibility was central to the case, and the judge arbitrarily excluded Tobin. No, it wasn't arbitrary. It was intentional. Here, Oberg's credibility was central, and Tobin is an expert in AFTE methodology and its shortcomings. He's experienced with firearms identification and examined Oberg's material. There was no legitimate state interest in excluding Tobin. Allen did not waive his right to the appeal of the Tobin issue by calling Warren. A party aggrieved by an erroneous evidentiary ruling is entitled to respond to the improper ruling without sacrificing the right to appellate recourse. Meaning, the fact, you know how in the prior, the state tried to say, no, well, he had a witness. He had Warren. No, he didn't have Warren. Because a party aggrieved by an erroneous evidentiary ruling is entitled to respond to the ruling by presenting an alternative without sacrificing the right to appellate recourse. Once the court excluded Tobin, Allen responded by calling Warren, but that decision did not waive Allen's right to appeal Tobin's exclusion. Okay. The error was harmful under both constitutional standard and the evidentiary standard. The state told the jury, Oberg's never been wrong, and Allen has no explanation of how his bullet from his gun ended up between the bodies of Abby and Libby, 6 inches from Libby's foot. Had the jury heard Tobin's robust impeachment of Oberg's bullshit methodology, the outcome of this case would probably have been different. The state says Tobin's testimony was inadmissible because it was not relevant to an issue before the jury. Two-mark identification has at least 2 subdisciplines, metallurgy and firearms identification. What sounds like metallurgy is exactly his specialty. ISP forensic firearms examiner Melissa Oberg testified that she used the AFTE 2-mark identification methodology and opined that there were 3 different 2-mark areas of significant agreement to show that the cartridge at the scene had been cycled through Allen's Sig Sauer model P226. Eric Warren, also a forensics examiner, testified that he reviewed Oberg's report, did not agree with her process of comparing a cycled cartridge with a fired cartridge, and found insufficient documentation to support her opinion. Woo! That's a statement there that is it's pretty hard to skip over, right? I want to read that one again. That was good. It said defense expert Eric Warren, who uses the same methodology as Oberg, meaning he knows it very well, testified that he reviewed Oberg's report and did not agree with her process of comparing a cycled cartridge to a fired cartridge. And he also found insufficient documentation to support her opinion or conclusion. Heavy stuff. Now, the state says Allen also proffered William Tobin. Tobin is an open critic of the AFTE and all firearms identification methodology. He believes the discipline is unreliable and should not be admitted in court. Court properly excluded his testimony because it was not relevant to an issue before the jury. Oh, really? Really? How is that? How is that? That makes zero sense to me. How is an issue not before the jury the validity of the process used to identify these quote unquote tool marks on the cartridge? The trial court, not the jury, determines whether expert scientific testimony is admissible under Evidence Rule 702B because the scientific principles upon which it rests are reliable. Allen never offered Tobin's testimony to exclude the firearms evidence as based on unreliable scientific principles under Rule 702B. I think that's false. Because the trial court found the firearms identification evidence admissible, it was for the jury to determine the credibility of Oberg and Warren. Yeah, but no, it was going to be Oberg and Tobin. You see how they twist the things here? This was supposed to be about Oberg and Tobin. When Judge Gohl excluded Tobin, Warren was the fallback witness or expert. So this whole rationale doesn't make sense to me. Anyway, I'm going to skip some of this because this is the state's gaslighting. It actually angers me. I'm trying not to get angry. But here, I got some highlighted stuff. Let's read this. Allen offered Tobin's criticism to discredit the accepted established methodology under the AFTE. No. Tobin was offered to critique Oberg's findings based upon her process and the metallurgy associated with the technique or the methodology. And then they keep saying, yeah, but he got to cross-examine Oberg, and he had Warren's expert testimony. He had Warren. So again, it's really not addressing the issue of the error in exclusion of Tobin. It's more so saying he had Warren, so he's fine. And another gaslight here says, for this reason, and due to the overwhelming evidence of guilt discussed in section B below, any error in the exclusion of Tobin's testimony was harmless anyway. Overwhelming evidence of guilt. You guys see that? Oh my
God.
Boo, 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 boo. Bruh. What overwhelming evidence of guilt? I'm still waiting for for any evidence of guilt, not a shred of it, right? Okay, here we go with Tobin. So the response to that is the appellate attorneys say the court committed error, reversible error in excluding Tobin. The state argues Tobin was unqualified because he's an expert in one field and cannot offer opinions in another, absent a showing of competency in that field. But Pruitt is an opposite. Tobin was not asked to perform a firearms examination or opine in a field outside of his expertise. He was proffered specifically, to explain the scientific community's critique of AFTE methodology, a subject that is squarely within his expertise in forensic metallurgy, material science, statistics, and 24 years of managing forensic metallurgy operations at the FBI laboratory. As a fallback position, the state claims that Tobin's testimony went to admissibility, which is for the court rather than the jury to decide. Yeah, that was the gaslight we were just talking about. This argument is contrary to law. Trial courts determine whether expert testimony is reliable and thus admissible under Rule 702. But once admitted, the jury decides whether the expert's credibility and the weight to give her testimony. Here, Tobin's testimony served both purposes. It went to the reliability and admissibility of firearms identification evidence, and the credibility and the weight the jury should give Oberg's conclusions, which were based on the AFTE methodology. Allen moved to exclude Oberg under 702, and at trial, the trial court denied the motion without hearing. Allen then proffered Tobin to attack the weight and credibility of her opinion before the jury, and the jury should have heard from Tobin. Excluding Tobin's testimony criticizing the firearms identification methodology is reversible error. Testimony was a question of fact for the jury. Thank you, Swade Smith. Thank you, Swade Smith, for the 99-cent super sticker. Do, 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 do. Swade Smith, y'all. Everybody give Swade Smith some love in the chat. All right, Swade. Finally, the state argues harmless error because Allen had alternatives to impeach Oberg, but by excluding Tobin, the court stripped Allen of his chosen defense. You see, that's what I was saying a few minutes ago. Allen's chosen defense. You can't say, "Oh, well, he had Warren. He had Warren." No, his chosen defense was Tobin, and the state stripped him. The court stripped Richard Allen of his chosen defense using Tobin that AFT methodology is not credible science.
Bruh.
And locked him into a narrower defense that conceded the validity of the only physical evidence against him. Allen's fallback witness, Eric Warren, is an active AFT board member who endorses the methodology. The jury heard a debate about whether Oberg applied the AFTE correctly, not whether AFTE is credible. This forced the substitution of Allen's chosen defense for, and this substitution is not harmless and affected Allen's constitutional right to present a defense once again. So you guys, oh, excuse me. You guys think we have touched upon a somewhat of an understanding of William Tobin and the exclusion of him and how this fits into this entire picture? That she committed reversible error by excluding the witness or expert who was going to provide him with his chosen defense about this bullet. You see, that's the key. So his chosen defense of using that sketch when it comes to Betsy Blair identifying, quote unquote, him, okay, that was improper. And then now, secondarily, improper to deprive him of his right to present his chosen defense for this bullet, the magic bullet. So the bullshit sketch identification of him as bridge guy, yeah, we're going to strip him of that, and we're just going to say he's bridge guy and have the world believe it, make the world believe it. And then the magic bullet that was planted, okay, yeah, we're going to take that magic planted bullet, the only piece of physical evidence that could be used against him, and we're going to deny him or strip him of his right to use his chosen defense about that bullet. That way we can railroad that through. So they railroad on the Betsy Blair through, and they railroad on the bullet. So they railroad bridge guy, and they railroad it's his bullet. They railroad it's Richard Allen, and they railroad it's Richard Allen. And as I mentioned at the beginning, the judge was responsible for all of that. I mean, can't make it up. All right. I think I skipped. No, we're good. Okay. Now we're going to get to my favorite. This is actually, let me come up here for a minute. This is actually my favorite right here. My favorite is Stacy Eldridge. Boy, she's a beautiful woman too. Stacy Eldridge, FBI, badass, beautiful woman, incredible discovery. she was the grand finale in Andy Baldwin's strategy for trial here. You know, she was supposed to be the big, like, boom at the end. Stacy Eldridge. And she was defeated by a fat, beer gut, overweight, balding, Google searching, forum reading, sit on his ass, hearsay providing, douchebag, bloodluster who wanted to put Rick Allen in prison for the rest of his life, named Christopher Cecil. So let's see what happened here. The court committed reversible error in admitting hearsay to rehabilitate the timeline upon which the state built its entire case. Okay, the state built its entire case upon the following timeline. Allen encountered the girls at 2:13. Oh my God, 2:13. You guys know me, you know.
Oh my God.
What the fuck? Bruh. 213. It's the cult, you guys. It's the fucking cult. I keep telling you. One day you all will realize. One day the world will realize we're dealing with the cult. We're dealing with the cult. 213, 213. If Allen committed the murders, there should be no human. No, I'm sorry, I skipped. Okay. He completed the murders alone, left Liberty's phone at the scene, was spotted by Sarah Carball leaving the scene at 3:56 p.m., never returned. If Allen committed the murders, there should be no human initiated activity on Liberty's phone after 3:56 p.m., period. But there was. At trial, the defense called Stacy Eldridge, a former FBI forensic examiner, who examined the very data from Liberty German's phone and testified that wired headphones or an auxiliary cable were plugged into the phone at 5:45 p.m. on February 13th, 2017, and then removed, oddly enough, at 10:32 p.m. For all of you in the back who I addressed earlier, that's two separate handlings of the phone after Richard Allen had left, according to the state's timeline, at 3:56 p.m. Two separate incidents of someone handling the phone. 5:45 p.m., 10:32 p.m. Well, guess what? In the geofence data, we have exactly that. We have exactly someone near the crime scene at both of those times within minutes being pinged in the geofence. Somebody else handled the phone twice after Richard Allen had already gone. This action would silence a phone call. She noted that the data showed, this is the FBI forensic examiner, showed that the data showed an incoming call moments, milliseconds, before the headphones or the auxiliary cable were inserted, suggesting someone was intentionally trying to silence Liberty's phone. Since the state claimed Allen left the murder scene at 3:56 p.m., Eldridge's evidence eviscerated the state's timeline and showed that someone else committed the murders. Now, the state responded by asking Christopher Cecil, its quote-unquote phone expert, whether water damage could simulate headphones being plugged into Liberty's phone. Over a hearsay objection, which means it was preserved for appeal, Cecil testified that he Googled it and found some unspecified, non-peer-reviewed troubleshooting forums reporting that it could. Cecil's testimony was absolutely inadmissible because it was totem pole hearsay. Unless our evidence rules provide otherwise, Out-of-court statements are not admissible for their truth. For totem pole hearsay to be admissible, each part of the combined statements must conform with an exception to the rule. Hence, or here, the post on the troubleshooting forum are at least double hearsay. First, it's on an internet forum, so you don't know who it is, right? Where they are, who they are, if they're telling the truth, if they're lying. And then it's the statements posted, whether they are statements that could be admissible for their truth. Cecil's status, furthermore, as an expert does not affect the hearsay analysis. Statements contained in a reliable authority can be admitted over a hearsay objection when used to contradict an expert who is testifying on the witness stand. But here, the online forum was neither reliable nor used to contradict Cecil. Rule 703 does not avail the state either. Under 703, experts may testify to opinions based on inadmissible evidence if the evidence is of the type reasonably relied upon by experts in the field. So let me ask you this. Are random Google searches at the last minute is that usually how an expert would rely upon information to do a last minute Google search in a random internet forum, whether it be Reddit, a Yahoo group, or whatever? This rule, however, does not authorize experts to parrot facts that the expert adds nothing to. Cecil added nothing here. He was merely a mouthpiece for the totem pole hearsay from the internet forum that he Googled. The error was constitutional. It's a constitutional violation. A defendant is entitled to a fair opportunity to defend against the state's accusations, which includes the right to impeach a witness through cross-examination when they provide a crucial link in the defendant's guilt. Here, the judge arbitrarily allowed the state to undermine Stacy Eldridge's testimony with a person's internet post. It was impossible for Allen to impeach the person through cross-examination. The error was harmful in that Eldridge's testimony undermined the timeline. It eviscerated the timeline on which the state built its entire case. Allowing the state to rehabilitate the timeline that tied their whole theory together affected Allen's substantial right to prevent a defense. Okay. And the jury's decision. All right, let's see. This is kind of out of order. Boy, I don't know where to find it. Hold on. Let's see. Oh, there you go. Now, the state says the admission of a possible explanation for a cell phone code was harmless. The admission of the Google search was at most harmless. Defense witness Stacy Eldridge opined that no, she didn't opine. She stated, see the fucked up part in that this is the state of Indiana for you. Stacy Eldridge did not have an opinion about whether this or not occurred or not. She stated the fact that was in the immutable cell phone data. But watch the semantics at play. Opined that between 5-4. No. She didn't opine. Okay, so see that word needs to be totally removed from that statement there. Stacy Eldridge stated that between 5:45 or at 5:45 and at 10:32, Liberty's cell phone registered a code in the Knowledge C database of an audio output start, which indicated that headphones or an aux cable was plugged into the phone. It's not an opinion, it's a fact from the extraction. She opined, there's that word again. You see that word again? She opined that this event required human interaction. That's not an opinion. It's logic. It's reason.
Bruh.
Allen offered this to suggest that someone else committed the murders because Carbaugh saw him leave the scene by 4 p.m. There was water and debris on the phone when it was found. To Eldridge's knowledge, water would not affect the plug-in data. The state's donkey 2 fucking cell phone quote-unquote experts, Christopher Cecil and Brian Bunner, testified that they didn't know what an audio output start means. What the fuck? These are your experts. These are your clowns in uniform. So Christopher Cecil, Brian Bunner, they don't even know what audio output start means. That's your Indiana State Police cell phone experts. Don't even know what, I don't know. On cross-examination, the state asked Cecil if he had done a Google search to determine if water damage could cause the output code. Richard Allen, through his attorneys, unsuccessfully objected on hearsay grounds. Preserved for appeal. Cecil testified that he found through the Google search that water damage or dirt within the headphone plug-in could cause the phone to register an audio output. Cecil acknowledged that he does not normally do Google research and that the information on the internet can be wrong. Bruh. This information was proffered as an alternative theory of the cause of the audio output code. But neither of the theories made it more or less probable that Allen committed the murders. Why not? Hold on. See, that's where, again, you got to watch how these guys are slick. You see what they just did? He's saying, yeah, the information was proffered as an alternate theory of the cause of the output code, but neither of these theories made it more or less probable that Allen committed the murders. How not? So if someone is handling the phone and plugging a cable into it at 5:45 p.m. and then hours later at 10:32 p.m., someone else is still handling that murder victim's phone. If someone else is playing with the dead girl's phone before putting it under her body, how does that not make it less probable that Allen committed the murders as a lone wolf perpetrator who you say left by 3:56 p.m.? You see how this doesn't make sense, and the state is absolutely lying to the judges and to you all out there. Excuse me. If someone is handling the phone after Richard Allen is at home with his wife, someone's handling it not just once, but once in the evening, and then 5 hours later, in the late night, someone is handling that phone, and then it's later found under a dead girl, and there's another one next to her. How does it not make it less probable that Allen committed the murders in the way that you say he did? And then they go with the gaslight. Allen's identity was proven through eyewitness testimony. Allen's statements to the police the cartridge from his gun found between the bodies and that we didn't let him defend, and the confessions, which we had to drug him and put him in solitary confinement for 13 months for it and threatened to kill him, but never mind that. Then another gaslight. Every line in here is a lie. The health app data showed the phone did not move after 2:32 p.m. No. The health app data showed the phone did not significantly move after 2:32 p.m. The phone can be handled without registering on the health app data. Period. Defeating any suggestion that the phone was returned to the crime scene after 10:30 p.m. Who says it was returned? Maybe it was left at the crime scene the entire time, but it could have still been handled right there on that spot. And any suggestion that another person was present at the murder scene at 5:45 p.m. and 10:32 p.m. during the height of the search for the girls, inserting, unplugging headphones from the phone was implausible. What?
I'm legally blind.
How is it implausible that someone is at the crime scene at 5:45 and 10:32? How is that improbable or implausible? Let's see. Are you saying you found the girls at either 5:45 or 10:32, that you had already found the girls? Something's not adding up here, because let me see. You have searchers out there, right, during those hours. You're saying that fact makes it implausible that someone's out there at the crime scene? Well, if you had searchers out there that would have seen someone toying with the phone, why didn't they see the girl? So that logic doesn't really add up. This is just a glaring violation of dignity on the part of whoever wrote this. During the height of the search for the girls, anyone inserting, unplugging headphones from the phone is implausible. Well, if you didn't see the two fucking dead bodies, who's to say you didn't see someone who was alive and capable of moving around and hiding and hearing and seeing you coming with flashlights and then moving out of the way? It's astonishing. Absolutely astonishing. All right. See if I can find this section, because they didn't really keep it in complete order. Here it is. So the appellate attorneys responded, the data on Liberty's phone is consistent with human interaction at 5:45 p.m. and the state's impermissible rebuttal was harmful error. Stacy Eldridge, a former FBI forensic analyst, found data consistent with a person interacting with Liberty's phone at 5:45 p.m. An incoming call arrived milliseconds before a wired headphone cable was inserted into the device, silencing it. The state concedes the trial court impermissibly allowed the state's witness to impeach this testimony with Google searches from anonymous troubleshooting forums. And the state resorts to arguing harmless error on two grounds: that there was no movement on the phone at 5:45 p.m. and the purported interaction coincided with the height of the search for the girls. But both arguments fail completely. The phone showed no steps, not no movement. And a person can interact with a phone without logging one. The search began sometime after 5, before the crime scene was located, precisely when someone with access to the phone would want to silence incoming calls.
Bruh.
The harmless argument also makes or misses the deeper point. The state's theory requires a single killer who committed the murders left the scene and was seen by Sarah Carvell walking west on 300 North at 3:56 p.m. But if someone was interacting with Liberty's phone at 5:45 p.m. to silence an incoming call, that person was at or near the scene 2 hours after Carball's alleged sighting. A single killer cannot have been seen leaving at 3:56 and still playing with the phone at the crime scene at 5:45. That's why it disintegrates the state's timeline. Eldridge's finding is not a credibility dispute about phone data. It is direct evidence contradicting the state's all witnesses saw Richard Allen timeline. Carball did not see the killer leaving because the killer had not yet left. Let me revise that. Carball did not see the killer leaving because the killers had not yet left. They were with those girls till damn near sunrise the next day, the next morning. And that's a goddamn fact.
The day since police made this tragic discovery, the Delphi community has been coming to terms, I should say, with a painful reality. Eyewitness News reporter David McAnally went back to the scene of the crime today, where neighbors still don't understand how this could happen to two young girls. Dave?
As police continue a very methodical investigation here, going down every road in the search for clues, some folks who live near the crime scene, they fear that their road will never be the same. The crime scene Thursday, a place property owner Ron Logan knows well, but never thought he would know for something so tragic.
I can't really wrap my emotions around it yet. It's so mind-boggling. I haven't really caught up. It hasn't caught up with me yet.
Up in
Bruh.
Without the internet forum hearsay, the jury would have heard or had Eldridge's findings standing unchallenged. Findings that, properly understood, do not merely undermine the step data, but unravel the state's entire timeline. And guys, I thought we were going to have enough time tonight to get all the way through this section, but we've run out of time. And so I guess it's going to take us longer to get through this than I thought. So I'll stop here and we'll continue in the next stream, and we'll cover Dr. Perlmutter's improper exclusion, the motion to correct error, and other issues. But I want to thank all of you for being here tonight. This was Delphi, the Appeal 3.1. The court denies Allen the right to present a defense. What that statement means is Judge Gull, this is the section of the appellate argument where it is absolutely made clear that Judge Gull denied Richard Allen his right to present a defense and a fair trial. 14th and 6th Amendment constitutional violations. This is not harmless error. This is constitutional right. And so this third leg of the appellate attorney's argument is extremely important, because judicial bias, judicial malpractice, prejudice, abuse of the bench, judicial corruption is a huge problem. And honestly, I believe in this instance, we're dealing with judicial corruption, which is something you're going to be seeing a lot of around the nation. It's already starting to become very obvious that you've got some very compromised judges out there. This being another one. And I think it's very well proven and all of this documentation. And I hope for oral arguments, which we should all be hoping for. And I guarantee you, if we get oral arguments, that will be exhaustively covered here. That's what's needed in this case. This is highly complex. It's highly, it has great implications for the citizens of Indiana. Or oral arguments should be granted. Okay. But I think it's clear here. You can see the soundness and validity of the appellate arguments here, and you can see the thinness and disingenuous nature of the state's rebuttal or reply here. And it really is a bad look. It's absolutely disgusting. So I think it's really important that we all continue to talk about these documents related to the appeal. We study and learn all the issues as experts so that we can go out and carry forward and educate those who don't know about the case or who gloss over or have questions about the appeal and don't really understand what it's about. We need to know all of these appellate issues absolutely clearly so that we can go out and discuss with individuals the egregious nature of the constitutional violations, et cetera, which what have that have taken place here, or what has transpired here. So hopefully for your study guide, you go back and you listen to this again, and you catch the main points we covered tonight, which were the Betsy Blair exclusion of her sketch, the exclusion of William Tobin as the chosen defense to impeach the ballistics testimony or expert witness from the state, and the Stacy Eldridge information that was impermissibly allowed to be rebutted with a Google search. Multiple layers of hearsay admitted to contradict Stacy Eldridge's factual findings that in the phone dump data, there was logged audio output, audio input, et cetera, et cetera. Headphones plugged in, headphones taken out at 10:32 p.m. So huge points there. Again, Betsy Blair sketch, William Tobin exclusion with the bullet, Stacy Eldridge being debunked by a fucking Google search from an internet forum, admitted as hearsay and allowed. Egregious errors on the part of this judge in her how was I going to put it? It's I'm at a loss for words. Her objective was met by her improper rulings and strong-arming bias and wielding of power from the bench. And that's absolutely unacceptable when we're dealing with multiple layers of constitutional violations. So we'll continue and look further into this document so that you will have all of this as a resource to get caught up to speed with the actual appellate issues that are going on here, and not just emotional garbage or bullshit peripheral information that the cranks and troll farm are presenting to you as distractions to keep you from looking at this very important stuff that we should be looking at. So with that being said, I don't know if many of you noticed, but I have decided that it's pointless to have two channels that are nearly identical to each other. So what I've done with the smaller channel that I had set up as a backup channel is I decided to broaden my coverage to the financial market, something that I do on a daily basis, very well educated in, I've had some success in, and I'm highly interested in. And so if you're interested in peaceful morning updates on the stock market opening and on the crypto markets and commodities in general, please go ahead and subscribe if you're not already at my other channel, which is the Prof Market Analysis, where we cover markets, crypto, macro, and commodities, live markets, key levels, low noise. It's a chill morning stream where we're covering the market opens, put you in a really good position to work on your investments, move things around, and at a minimum, gauge an understanding of what's going on in the financial markets as they react to geopolitical events. And with that being said, I want to thank everyone for being here. I truly appreciate it. If you're on the replay, please do me a favor, hit the thumbs up and leave a comment down below. And I'm going to say goodnight to everyone in the chat, especially I want to shout out Swade Smith and MJ Lewis for the sponsorships tonight. Swade Smith and MJ Lewis. Also in the live chat, I see Giuseppe, Deb, oh hey Christina, Trial Junkie, Mustang, Carol, Matt Payton, Support with Stefa, Quadaxo Mimi, Critter Mama, 4 Pitbulls Across America, Ninja Warrior Assassin, David Rogers, Dennis McKean, Monday, Vicarious Vigilante, Peggy O, Bezo Jones. Who else we got up in here? Nicole Watt was here earlier. I'm not sure if that was the real Who's Her Daddy or not. I need someone to let me know because I blocked that individual. It seemed like a troll account to me. And of course, we had our jackass meth smoking crackhead chomo pedophiles trolls that came in tonight to throw us off course. But Deb took care of them appropriately. Rebecca Ann was here. Violets and Grace was here. I don't want to miss anyone. Jenny Hurd. Okay, bunch of folks. I'm glad to see all you guys. Thanks so much for being here. Tammy. Hey, Tammy. All right, great. So you guys hit the replay. If you're just coming in, please hit the replay. And I'll see you guys extremely, very quickly soon. All right? See you guys later.
This is bullshit, Alado.
Bruh.
Prof is a fucking terrorist, a fucking pedophile, sympathizing fucking terrorist.
It's not productive. It's kind of gross and icky. And I feel like it tells us more about them than the people they're trying to degrade. They're always trying to degrade someone.
It was our job to help law enforcement.
Bruh.
Obsessed junkie stalker.
Oh!
It's not productive. It's kind of gross and icky.
Fuck you.
It was our job to help law enforcement.
Prof is a fucking terrorist.
This stuff's coming to a close. There are more than one person involved with this case. It's
Bye, you fucking hoe.
Prof is a fucking terrorist. A fucking pedophile, sympathizing fucking terrorist.
It was our job to help law enforcement.
Fuck you. Fuck you. Fuck you.
It's not productive. It's kind of gross and icky.
This is bullshit, Alado. This is bullshit, Alado.
Bye, you fucking hoe.
It's not productive. It's kind of gross and icky.
Prof is a fucking terrorist.
It was our job to help law enforcement.